Welcome to Contracts, another episode in Tom's Next Level Exam Prep Series. I'm Tom, and I designed this series to help you pass your real estate exams, just like I've helped hundreds of my previous students. I really urge you to watch my Welcome and my Exam Insights and Strategies videos for a complete overview of this process. You'll learn how to get the most benefit from these topical videos. Here's some of the most important points from my welcome video. I'm focused on Test World in my topical videos. They're designed just to be a supplement to your current education provider's course materials. I'm not going to reteach the class. So please take lots of notes. The more notes you take, the more things you'll remember for your test. That's a proven fact. Okay, with those key points in mind, let's get started on contracts. So grab your course materials, grab your notebook, grab your positive attitude, and let's get into Test World for contracts. You should know for contracts, on the test, many of the questions are going to just refer to general contract law, not specifically real estate. So under the heading of general contract law, there are two types of contracts. Your express and your implied contracts. Now you had those in your courses, you know what those are. The express contracts, all the terms are expressly laid out. Here's where students miss this test question. They'll ask you, can an express contract be oral or written? The correct answer is yes, but many students say no because they remember another part of the course said you can't have an oral contract for the transfer of an interest in real estate. That's true, you can't do that. But with regard to general contract law, can an express contract be oral or written? The answer is yes. Remember that one for the test. Implied contracts, you know what those are. You walk into a restaurant, you order a meal. There's a contract involved there, but the contract parties indicate by their intentions to enter into the contract. You order the meal and you eat the meal, you're expected to pay for the meal, okay? An implied contract is not in writing. So know the difference between those two, particularly that you can't have an oral contract for transfer of real estate, but oral express contracts are generally legal. These three categories of contracts always give students fits on the test. There's only three, but let's go through basically what you should look out for on the test. A valid contract, pretty straightforward on the surface. It contains all of the essential elements of a valid contract. The other one that's easy to understand is a void contract. A void contract is just missing one of those elements. So a contract can either be valid or void unless, and here's the testable point you want to watch out for. A voidable contract is one that one of the parties may disaffirm the contract and be able to get out of it. Usually on the test, they use the example of a minor or somebody under duress. If I hold a gun to somebody's head and say, sign the purchase agreement because I'm going to buy your house, they've signed that contract under duress. And so they can void out the contract by claiming and proving that it was signed under duress. The most often used example on the test is a minor. Can a minor sign a contract for the transfer of real estate? Can they sign it? First question. Yes, of course they can sign it. Is it a valid contract? No, it's not valid because they were a minor when they signed it. Is it automatically void? No, it's not automatically void. The minor is able to back out of the contract if they choose to because they're a minor. But that also means they could do what? They could go forward with the contract if they wanted to. Is it legal in the United States for minors to buy property? Sure, they can do that. So if you see voidable on a test and you see either a minor or duress in the question, then the correct answer to that question is going to be a voidable contract. Not automatically void and not automatically valid. The subject of enforceability of contracts will definitely be on the test. So I want you to know these two statutes, statute of frauds, statute of limitations. With respect to statute of frauds, I'd have you grab your notebook and make this note. Statute of frauds equals in writing. Statute of frauds says certain contracts must be in writing to be enforceable. And in our venue here, those are going to be contracts for the transfer of any interest in real property. A purchase agreement, a listing agreement, a lease, they have to be in writing due to the statute of frauds. I want you to make those word associations. The statute of limitations just deals with time. 10 days, 2 years, 6 months, all the time periods you've seen in your coursework are there because of the statute of limitations. Things must be performed within that time limit or the contract could easily become unenforceable. So the note for your notebook is statute of limitations deals with time. Laches means at some point a judge, and laches is determined at a judge's discretion, a judge in a lawsuit may determine that taking the action in court right now would be overly detrimental to one party or the other. So the judge may call a timeout, and the judge may enforce the doctrine of laches, which gives the judge's discretion to say, we're not going to do this right now. We're going to hold off on this court case. We're going to hold off on reviewing this contract because it would penalize one party more than another. Laches, you can think of it this way. The judge might latch them out of court, might lock them out of court. You've reviewed in your coursework the stages or the steps in a contract. Here we're talking specifically a real estate contract now. A buyer makes an offer to a seller and the seller may choose to accept that offer. Once the offer's been made and once the offer's been accepted, here's the test question. Is the buyer, is the offeror obligated to perform on that contract as soon as the seller accepts it? The answer is no. The key point they want on the test is communication of that acceptance by the seller has to be made to the buyer. And they aren't going to say buyer and seller, they're going to say offeror and offeree. So let's do that. The offeror makes an offer to a seller who is the offeree because they received the offer. The offeree signs it and accepts it, but it's not a valid contract until communication of that acceptance by the seller has been made back to the buyer or the buyer's agent. That's a key point. Communication of acceptance has to occur before the contract is considered valid. Counteroffers. The one key thing they're looking for in a counteroffer on the test is anytime a seller or an offeree counters an offer from a buyer, that counteroffer, that change to the original offer, terminates the first offer. Terminates the first offer. And guess what's happening now? The seller is making an offer back to the buyer. So terminates the original offer is the key testable point. It's also good to point out here that this is the only time in real estate where the term offeror and offeree can switch places. Step one, buyer makes an offer to a seller. The offeror makes an offer to the offeree. The offeree counters it, which means they what? The first offer they received is no good. It doesn't exist anymore. They made a change to it. So now the seller is actually countering back to the buyer, which means the seller is making an offer to the buyer. The seller is now the offeree and the buyer is the offeror. And the other clause you'll see in contracts that'll be on the test is time is of the essence. What the heck does time is of the essence really mean? It's usually just one line, and typically you'll find it in every single purchase agreement. Time is of the essence legally means that any time frame laid out in this purchase agreement must be adhered to or changed in a valid way, or the purchase agreement may be declared null and void. Typical example I can give you is a closing date. Time is of the essence in the purchase agreement and the closing date is spelled out as August 10th. And the document signed and accepted by all parties. And all parties know it's been signed and accepted. What if a week before closing, one of the parties calls the other one and says, hey, can we close a couple days later? Can we change the closing to the 12th from the 10th? And if all parties agree, can they change it? Sure, they can change it. Long as mutual agreement with all parties, so the closing date is changed. Well, when that happens, as a real estate licensee, you better make sure that everybody who signed the purchase agreement signs an amendment that changes the closing date to the new date. Because if that first closing date goes by, there's nothing been signed that says it changed. Guess what? The original contract could be called null and void because of the time is of the essence clause in the contract. They'll give you some examples in test questions to make sure you understand the difference between a bilateral and a unilateral contract. Basic differences are laid out here. You had these in your coursework. A bilateral is two promises, a promise for a promise. Typical example would be a purchase agreement. I promise to sell you my house if you promise to buy my house and you agree on the terms. Purchase agreements are bilateral contracts. A unilateral contract is where only one of the parties makes a promise. An example of that would be an option agreement. If I come to you and say, I'd like to buy an option to buy your property. Let's use that as an example. I want to buy an option to buy your property, which means we'll talk about options in a minute, but it would basically work this way. I give you some money in the option agreement, and you give me the option to buy the property within a set period of time. Let's say within a year, you've given me an option to buy your property for $300,000. I give you some option money up front, but now who's made promises? Did I promise to buy the property? No, I have an option to buy the property. However, did you as the seller make a promise to sell it to me if I choose to buy it? Yes, your promise is there in the option agreement. So if I come in to you within the next year and say, I've decided I want to buy your property, you have to sell it to me. Yes, you've promised to sell it to me. But I did not promise to buy it. I bought the option. So an option agreement will be the most common example for a unilateral contract. Let's take a little closer look at option contracts. You remember in my welcome video and my exam insights video, I said all of your test questions are going to be multiple choice questions, typically with 4 choices. This is a great example on this slide of how it might come out in a test question regarding option contracts. Question likely will go something like this. All of the following things are true of an option contract except. And the choices will be things like, is there a fixed price? Yes, there is. Is there a fixed time period? Yes. Okay. Is there an option fee normally paid by the optionor? Yes, there is. And are option contracts bilateral contracts? No, they're not. They're unilateral contract. So if one of the choices was bilateral contract, that would be the correct choice for an except question because it doesn't apply to option contracts. And those are good things to remember for option contracts up front and how they differ from a right of first refusal. You may get one question on the test about the differences between contracts, option contracts, and a right of first refusal. An option contract, remember I came to you because I want to buy an option to buy your property. We know how much the price is going to be. We've established the time period. And I've paid you an option fee up front. All of those things are set in stone. The only thing I have to decide is, within the time period, do I want to buy it or not? That's what an option agreement is used for. Many times by land developers, things like that. The time they get to analyze the deal and exercise their option or not gives them an opportunity to go maybe get rezoning done, maybe see if they can do what they want to do with the land. Who normally uses option agreements? They may ask you that on the test. Good place to make a note in your notebook. Where do you often see option contracts? Usually a land developer who wants to buy raw land and then subdivide it and sell lots and homes, would buy an option up front to make sure they could get everything done they want to do with that property. Now that's dramatically different from a right of first refusal. Maybe I came to you and said I'd like to buy an option to buy your property for $300,000 within the next year, and here's $10,000 earnest money. You might say to me, no, I don't want to do the option. I don't want to sell you an option. And you say to me, you know what you will do for me? You'll call me if anybody else wants to buy the property, and you'll give me a right of first refusal. Well, if you give me a right of first refusal, what does that mean? Is that really a contract? No, not really. It's a promise. Maybe it's in writing, maybe it's not. But you're telling me you promise you'll call me if somebody else comes and offers you money for the land, that you'll call me and give me the chance to buy it before you sell it to anybody else. So what are the difference between the right of first refusal and an option? Well, there is no set price. There is no set time period. As a developer, I don't like a right of first refusal. The land might go to $2 million, and then I wouldn't want it. So those are the differences between right of first refusal and an option contract. Here's a couple more terms that will definitely show up on the test regarding contracts. Executory contract versus an executed contract. Let's talk about executed first. The word is past tense, it's done. That's the best way to remember which contracts are executed. It's a purchase agreement that has closed already. The contract has been completed. Purchase agreement is closed. It's an executed contract. Well, an executory contract is one that's been agreed to, everybody's signed it, but we're waiting to close. That's the best way to think about an executory contract. Purchase agreement, all the signatures are there, closing date comes up in 3 weeks. That's an executory contract. Executed, again, I remember it this way. Executed means past tense. It's done, it's over, it's already closed. Good way to keep those two separate. Very often you'll see questions on your exam about what happens if there's a breach of the contract. What if one of the parties breaches the contract, doesn't perform on one of the promises in the contract? What remedies are available and which parties are they available to? So I'm going to review that with you for the 4 that are on the screen here. And I want you to grab your notebook because there'll be a lot of information here. I'm going to share with you how they're going to show up on the test. Liquidated damages. Liquidated damages, number 1, is money. And it's typically only available to a seller if the buyer breaches the purchase agreement contract. And it's usually only available to the seller because the seller in a typical transaction is the only one who has some of the other party's money. Remember, the seller has earnest money from the buyer. If the buyer decides, I don't want to buy the house, the seller might say, okay, I'll let you out of the contract. We're not going to force you to buy it. But as a seller, I'm going to keep your earnest money as liquidated damages. And that's how that phrase might show up in the test. Earnest money may be kept by a seller as liquidated damages if the buyer breaches the terms of the contract. Or another remedy, and this one is available to both buyers and sellers, is a suit for specific performance. If the buyer decides they just don't want to buy the house anymore, the seller could sue them for specific performance and force them to buy it. Very difficult for a seller to sue a buyer for specific performance. Hard for me to say, because there's financing involved and money and all that. A suit for specific performance usually occurs if the seller changes their mind and says, oops, we don't want to sell, we love our house too much, we're not going to close. The buyer could file a suit for specific performance and force the seller to transfer title and go to closing. So that specific performance lawsuit is available to both buyers and sellers. That's a very testable point. And in some cases, if it goes to court, a judge may award compensatory damages and punitive damages. Compensatory damages may be awarded to a buyer if the seller says, I don't want to sell my house anymore. The buyer says, okay, I'll let you out of the purchase agreement, but the buyer says to a judge, I've incurred a lot of money and a lot of costs. I've got places I've got to stay. I got to get a hotel room. I've got to do something with all my stuff to store because the seller decided not to sell. So a judge may award, in that instance, a buyer compensatory damages to compensate them. And that's what the root word is there, compensation damages, for somebody who has lost money because somebody else, the other party, breached the contract. And the other form you don't so often see in real estate transactions is punitive damages. A judge may go over and above all of that and award some damages to one party who was harmed because the other party breached the contract as punishment for breaching the contract, basically as a deterrent for future people who might decide they want to breach contracts. So punitive damages are punishment. These two words always give people fits on the test because it's easy to get them mistaken and mixed up. And quite frankly, a lot of existing agents in the marketplace today use either one or both of those terms improperly. So let's know the difference between an addendum and an amendment. Let's talk about the basic differences. An addendum adds information. It's typically added to a purchase agreement. And think of these phrases you've heard. I want to buy your house, so I make an offer in a purchase agreement form. But I also want to let you know that my offer is contingent upon me selling my house, contingent upon me getting financing, and contingent upon me selling my existing home. All three of those would be addendums to my purchase agreement. I would give you an addendum for financing. I would include an addendum for the sale of my current home. I might include a home inspection addendum. It goes with the original purchase agreement. That's totally different, totally contrasted to what an amendment is. An amendment changes an existing contract to have some different information. An amendment changes an existing contract where an addendum adds information. Let me give you a quick little tip I got from a student many years ago about how they remembered the difference. Think about the Constitution to the United States, drafted when? 1776. Think about that as a document. Now, have we as a country changed the terms and conditions in that document several times since 1776? 20-some plus times? Yes, we have. What have we added to our Constitution? We've added amendments. Fourth Amendment, Fifth Amendment, 22nd Amendment, whatever the amendment is, we've added an amendment to an existing document to add information and change information. So that's the cleanest way I can give you to help keep the difference straight between an amendment and an addendum. Here's some more examples of those contingencies that we just talked about. All of these contingencies would be added to a purchase agreement offer as an addendum. The most common one is going to be financing. I'll agree to buy your house, but there's a financing addendum that says if I can't qualify for financing, you'll agree to cancel the purchase agreement and give me my earnest money back. Also, I've got financing highlighted there because it is the most often addendum you'll find in a purchase agreement. And that'll be a test question. Which of the following addendums is most common in an offer? The correct answer is going to be financing. The other addendums that we talked about already were inspection. I might decide to get a home inspection. I'll include that addendum with my purchase agreement offer to you. And it'll say that I want to have the home inspected, and if I don't like the inspection, I can cancel the purchase agreement and get my earnest money back. And the same would be true of sale of my current home. I need to sell my existing home before I can buy yours. That would be an addendum. Most common contingency, financing. Remember that one for the test. I want to share with you how some information about leases is going to show up on the test. You know what a lease is, you had that in your course materials, but here's the verbiage, the terminology they're going to use. In a lease, the lessor, who's that? That's the landlord, transfers their right of possession to the tenant. But the landlord keeps Their reversionary right simply means when the lease is over, the landlord gets their right of possession back. It reverts back to the landlord. So look for the terms lessor, lessee. Transfers the right of possession. Lessor retains a reversionary right. Look for that terminology with regard to leases. They'll ask you about the distinction of a lease purchase contract. What makes it different? Well, if you want to lease my house from me on a lease purchase contract, that means I agree to take some of the money that you pay me every month for rent, and I'm going to apply it towards a set purchase price that we established in the beginning. Okay? When do you get title to my house? After the lease purchase agreement terms are all complete, I've received all the money that I need for you to purchase the house, then you get title. Title only transfers on a lease purchase contract when the lessor receives the total purchase price. 3 different types of leases basically, and I want to make sure I go over with you the important buzzwords and terminology they're going to use on the test. A gross lease. A gross lease, you recall from your material, is one where the tenant pays a fixed rent, and that's it. You pay $1,000 a month for my house to get possession, and I pay everything else. What types of properties are a gross lease normally used for? And that's residential property. That's the word association for the test. Gross lease, normally used for residential property. A net lease is normally used for what? Commercial property. And how does a net lease differ from a gross lease? In a net lease, the tenant pays a base rent plus a share of all the expenses of the property. Like a shopping center, there's common area charges, things like that, maybe their own utilities. So in a net lease, the tenant pays rent plus other costs, some other expenses. And a net lease is commonly found in commercial property. Our third type of lease is a percentage lease. And here's a key word association for the exam. Percentage leases are often found in a retail setting, where the retail store in a mall or a shopping center will pay a base rent plus they'll pay a percentage of their gross income. Those are all key words, percentage of their gross income. Here's an overview of the 2 contracts you'll deal an awful lot with in your career and you'll see an awful lot of on your exam. Agency contracts and purchase contracts. Agency contracts are buyer and seller representation contracts between the buyers and the sellers and your broker. But there are essential elements in those that you'll need to know for the exam. Oh, a couple of them might be the expiration date. There has to be a definite expiration date. On a listing agreement, all owners must sign the listing agreement, no matter how many owners there are. There has to be a clause that details your compensation and how that compensation is going to be computed. And again, who are the parties to an agency contract? Don't forget this for the test. The parties to an agency contract are the broker and their principal, who is what? The buyer or the seller. Or it could be landlord-tenant. But the broker is a party to an agency contract. As a salesperson, are you a party to an agency contract? No, you're not. Remember the phrase from earlier classes? The broker owns all contracts. So it's the broker plus their principal. Buyer or seller, landlord or tenant, okay? Purchase agreement. You have to know the essential elements to a purchase agreement. They're going to be basic things like, when's it going to close? What's the legal description? Again, all the sellers have to sign a purchase agreement. Here's a little test quiz for you right now. Is earnest money required for a purchase contract to be a valid purchase contract? People get this wrong on the test routinely. Is earnest money required to make a purchase agreement or purchase contract valid? The answer is no. Earnest money is not required. You want to make a note? Earnest money is termed good faith money, but it is not a requirement for the purchase contract to be a valid contract, okay? There may be contingencies in the purchase contract. We already talked about those. They could be contingencies like inspections, financing, sale of a current home. All of those contingencies would be included in the purchase contract when the buyer makes an offer to a seller as what? Addendums. They are addendums. All of these are addendums to a purchase agreement. So let me ask you this one question real quick. What is the most common contingency included in a purchase offer? What's the most common contingency? We mentioned it earlier. They'll ask you this on the test. Financing. A contingency for the buyer to get financing is the most common contingency addendum included with a purchase offer. Well, that's it for my video on contracts. I hope you found the information helpful and somewhat useful. I wish you good luck on your exam. Please make note of the national exam topic videos I also have out there. If you want to brush up on any of those or refresh yourself before you take your exam, please feel free to do that. And again, thanks for watching. Stay positive and stay focused. If you like my videos and want to subscribe to my videos, I would be very happy to send you updates on my career prep and my skills prep series as they come out. So feel free to do that if you like. Any comments are always appreciated. And if you know someone else who's in the process of trying to pass their real estate exam, please feel free to share my video series with them.